Hi everyone, I'm JD Hoovener, your host of the Bold Today Show, where you, the inventor, entrepreneur, or business owner, get your daily inspiration to make the world a better place. Alright, we're in the middle of our 10-part litigation series. This is about patent litigation, and just yesterday we looked at the primary statute that covers direct infringement. Today we're talking about what's called induced infringement, and it's a mechanism that came about in a case that is sort of like a supply chain, and a defendant was trying to get around the rules, right? Create a loophole in the infringement statute, and so now under 35 U.S.C. 271B, inducement is still a vehicle that a defendant can be held liable for infringement, even if they actually weren't the ones doing the direct infringement. So think of a scenario, let's say a tire manufacturer, okay? It actually gets produced, most of the tire does, in, let's say, China. It's distributed over the Pacific Ocean, and the treads are assembled to the main part of the rubber here in the US. Okay, and that's done by a third party. Okay, so party A distributes the raw materials to party B here in the US, and by doing that, they have knowledge of the patent. And the reason why they're shipping parts is because they know that the entirety of that tire is covered under a patent. And so if they do that, what they're doing is they're inducing party B to be the direct infringer. And so when those two components are combined and then that's sold to the general public or to a third-party retailer, that's when infringement occurs. So a plaintiff, that is, say, the patent holder, or a company that now has been assigned the rights, has the ability to go after both party B and party A for direct infringement. There are some elements that need to be shown. One of the most important ones is if there actually must be direct infringement. And so under the scenario I painted before, if party B actually never sells that tire, and they actually never combine those two elements into that one particular piece that's patented, there truly is no infringement, and so there's no underlying liability there. So the plaintiff in this case would still need to show some of those core elements, but if they can point to the fact that party B made, used, sold, or imported into the U.S. anything that's covered under their patent claims, everyone in that chain of title, chain of command, is likely going to be held liable. So this is an interesting subject for you. You've got a patent that's already been issued. You want to get more information about your enforcement options, or maybe you're way back at the early phase and you're still coming up with ideas. That's fine too, and you want to get a hold of someone to just sort of start the process. Give us a call at 800-849-1913 or visit us at boldpatents.com. We'd love to sit down with you one-on-one and do a consultation. We don't charge for this fee. It's important that you be able to get the information you need to make a good, sound business decision on your invention. I'm JD Hoovener, your host of the Bold Today Show. Hope you have a wonderful day and a good rest of the week. Go big, go bold.